All right. So, good morning, everyone. Welcome to the second panel of today's conference. My name is Ayelet Banai. I'm a faculty member at the University of Haifa in political science and European studies. And it's an honor to chair this panel today with three very distinguished speakers. I'm going to present them now very briefly and just dive directly into the topics of this panel, which deals with the ban on kosher and halal slaughtering in European countries and how the European Court of Human Rights, the European Court of Justice, has dealt with this ban. So we have Professor Arie Reich, who is the former dean of the Faculty of Law at the University of Ilan University and currently the vice rector of the university. He's also a member of the Israeli Association for the Study of European Integration, which hosts us today, and has a very long and distinguished record in research on European law. So I'm going to leave it at this because doing here the full list of titles is going to take us a long part of our time. We also have Professor Guy Harpaz from the Hebrew University of Jerusalem, who's also a professor of law and international relations with, again, expertise in European law. And Professor Arie Zivotofsky from Ilan University as well, and is a professor of neuroscience, and also participated in one of the Horizon research groups dealing with these issues, if I understand properly. And it's a pleasure also to have you here. We had a bit of trade among ourselves with the time of each speaker. So I think Professor Reich is going to start, right? You're the first speaker on our panel today, and you have about 20 minutes to present, including presenting the issue itself for those who are not familiar, and then we can go into a discussion on the issues. Thank you.
Thank you. Okay. So first of all, I'm sorry I couldn't be with you in Jerusalem. Do you hear me all?
Yes.
Yeah. So I'm right now in Switzerland, in CERN, which is the European Center for Nuclear Research, which is another European institution. And you probably have heard that the new president of this institution is an Israeli professor, Professor Rabinovich, which is, I think, is a very nice sign of the involvement and integration of Israel in European affairs. So my topic today, I'm going to put on my time, is the issue of kosher and halal slaughtering before the Court of Justice. This is in a paper that I wrote together with Guy Harpaz, who is also going to speak later on, and which has been accepted for publication in European Public Law, which is an important European legal journal. So the background is that in 2017, one of the three provinces of Belgium, Flanders, amended the regulations relating to slaughtering and required that all slaughtering had to be done by pre-stunning. Stunning means that there is something called a captive bolt. You can see on the picture where you're supposed to hit the animal in the head. However, this regulation provided that the stunning could be reversible, in other words, not lethal, and then the slaughtering with the knife could continue. However, de facto, this means that kosher shchita, kosher slaughtering, could not be performed because under the Jewish halacha, the Jewish law, an animal has to be alive and with no blemish before it is being slaughtered. And this kind of hit in the head with the stunning actually causes damage to the animal, and as a result, most most of the Jewish authorities say that this is impossible. Also, some of the Muslim authorities hold that this does not make possible halal slaughter. Now, as a result, the only kosher slaughterhouse in Flanders was closed. And soonly later, afterwards, Wallonia, which is the second province of Belgium, followed suit and also adopted a similar ban. I should mention that in Flanders, we have a big Jewish community, ultra-Orthodox community, and they are now relying on imported meat as a result of this ban. So as a result, the organization of Jewish communities in Belgium decided to petition the Constitutional Court of Belgium, and also some Belgian Muslim organizations joined this petition, which they also found the ban very problematic. And they claim this is infringement of freedom of religion, unjustified discrimination, etc. under Belgian constitutional law. We won't deal with Belgian constitutional law. We will deal with the arguments under European law, EU law. And here the main argument was that this ban violates a council regulation, which deals specifically with slaughtering. It also violates the Charter of Fundamental Rights, such as freedom of conscience and religion, equality, etc. And since questions of European law were raised before the highest court in Belgium, under EU law, this court was required, and it did so, to refer the question to the European Court of Justice, the highest court of the EU in Luxembourg. Now, in order to understand the legal aspects of the case, we need to understand that the regulation in the EU that deals with slaughtering of animals indeed also requires that animals shall only be killed after stunning. However, there is a derogation, there is an exception to this rule found in Article 4.4 in relation to slaughter prescribed by religious rites. So the EU knew that under both for kosher shechita and halal shechita, stunning, pre-stunning is problematic, and a slaughter has to be done by a kosher knife in a certain particular method. So they provided for an exception for such ritual slaughtering. However, there is a provision at the end of the regulation, Article 26 2c, which provides in a general language that member states may adopt national rules aimed at ensuring more extensive protection of animals at the time of killing. So in other words, the regulation, as far as it protects animals, is like minimal requirements for all EU member states, but they are allowed to be more strict in certain matters. And what the Flemish authorities were claiming is that under this article, they are allowed basically to annul the exception under Article 4.4 and to ban methods of slaughters that do not include pre-stunning, even if they're done under religious rites. And this is the question that came before the court. Now, as you know, in the European Court of Justice, we have a procedure that before the court itself makes its rulings, there is a judge called the Advocate General. This is a system taken from the French Court of Administrative Law and the Conseil d'Etat, who first writes a legal opinion, a very elaborate legal opinion where he explains and analyzes the whole questions, and he makes recommendations to the court of what he thinks that the ruling should be. And the Advocate General Hogan suggested and came to the conclusion after an elaborate analysis that the Flemish decree is incompatible with EU law because it violates both regulation and the EU Charter. But what was very surprising in this case was that the ECJ did not adopt the Advocate General's position and ruled that the Flemish ban is not incompatible with EU law. Now, in most cases, the court accepts the Advocate General's position. In some minority cases, which are not very common, it rules opposite. And this is one of those rare cases. So what did the court decide? So the court did acknowledge that ritual slaughter falls within the scope of freedom to manifest religion, which is guaranteed under Article 10.1 of the Charter of Fundamental Rights in the European Union. And they also acknowledge that the Flemish ban entails a limitation on this exercise of right of Jewish and Muslim believers to the freedom to manifest religion and to eat meat that has been slaughtered according to their rules of their religion. However, the court considered that this limitation meets the requirement, the condition. We all know that no rights are absolute. You can override certain rights, and if certain requirements, conditions are fulfilled. And the court in this case came to the conclusion that all these conditions have been fulfilled. Why? So first it says that it's provided by law. Yes, indeed, it's by Flemish law. And it respects the essence of Article 10. Why? Because it is limited to one aspect of the specific ritual act of slaughter, and that act of slaughter is not, by contrast, prohibited as such. Now, I quote this from the judgment, but I have to tell you, I do not understand what it means. It doesn't make any sense to me, this quote, because as a matter of fact, the kosher slaughter is prohibited as such, considering that all religious Jewish authority says that you can't do it this way. It means that de facto it's prohibited. And then the court says that this limitation meets an objective of general interest recognized under EU law, which is the promotion of animal welfare, which is enshrined in Article 13 of the Treaty on the Function of the European Union. Indeed, animal welfare is one of the values enshrined there. And then it goes on and says that the ban is proportional because it settles for reversible stunning. And this is also a strange statement because, again, it doesn't solve any problem. The fact that it's reversible, considering that kosher slaughtering cannot be done in such a way. And then they talk about subsidiarity. In other words, they have this feeling that they have to give the member state, or in this case, the provincial authorities, a wide margin of appreciation and a certain level of subsidiarity, and to decide by themselves what they want within their territory. And finally, it also dismissed the arguments about discrimination, which I'll talk about later. So in the article that we've published, that we will be published, first of all, we raise questions whether indeed it's very clear that the use of a captive bolt inflicting a forceful strike on the animal's forehead is more humane than kosher shchita. I'm not going to go into that because we have here with us an expert on neuroscience, which he will talk about that. We just raise question and basically say that the science on this issue is not clear. But going to the legal aspects, we are of the opinion that the court did not strike a fair balance between freedom of religion and animal welfare, because an outright ban is not a compromise. You didn't give anything to freedom of religion, so it's not a fair balance. And when you read the decision, you get the impression that the judges were of the opinion that the laws of kashrut could be changed, and that they also have to compromise somehow with their and adapt themselves to how the European judges and legislators believe that things should be done. Seemingly not understanding that these are ancient laws and that there is certain strictness in them that cannot be changed. And in that sense, this goes against the very essence of freedom of religion, where you're not supposed to change religion. You're supposed to tolerate it as it is, and give it room for this religious minority to practice their religion the way that their religion prescribes, not the way you think they should be doing. And I think that Joseph Weiler, in a amicus curia brief that was presented to the court on behalf of the Association of Jewish Lawyers and Jurists. I think he put his finger on the problem where Christian judges have a difficulty to understand the role of nomos, of law in religion, because the whole essence of Christianity, which, as you know, developed out of Judaism, is that Paulus annulled, canceled the whole idea of law and put everything into belief and faith. It's all about faith. So Christian judges, which the whole court is made up of Christian judges, have a difficulty to understand the importance of law in their fellow religions, the two other world religions, which is Judaism and also in Islam, the same role for nomos. Now, we think that the fair balance is found in Article 4 itself, because the provision provides that all slaughter in general must be made by pre-stunning, but there is a very, very small percentage of religious ritual slaughter within the European Union for these minorities, and it can be accepted from this requirement. And indeed, Article 13 of the Treaty of Functioning of the European Union, which the court relies on, it itself speaks about animal welfare, but qualifies animal welfare by several other values, and other certain values override it. I mean, if animal welfare would be an absolute or superior value, then we wouldn't slaughter animals at all, right? We wouldn't eat, we would all become vegetarians. But obviously, most people do eat meat. So there are other values that override it. And one of them is freedom of religion, which is specifically mentioned in Article 13. So the reliance on Article 13, I think, is very problematic and unconvincing. And generally speaking, the whole concept of the judgment whereby animal rights or animal welfare is taking precedent over human rights seems to be very problematic in my mind. As is another concept of this ruling, which puts TFEU provisions, treaty provisions, over fundamental rights protected by the Charter. The whole idea of the Charter is to provide for superior rights that should limit the treaty and limit EU law, and not that the TFEU should override the Charter. And coming to the regulation itself, we think that this interpretation given in such a way that Article 26 basically overrides Article 4.4 and basically makes it irrelevant. It makes it meaningless. So Article 26 speaks in a general way that member states may adopt a more extensive protection. And that could relate to how the animal is transported to the slaughterhouse, how it's held during slaughter, all kinds of measures you can take to limit the stress on the animal, etc., etc. But this general provision cannot be interpreted in a way that it basically makes an express derogation in the beginning of the regulation meaningless. That does not make sense. That is not a reasonable interpretation of this provision, which was also the opinion of the Advocate General. And the court's interpretation also contradicts Recital 18. Recital 18 relates specifically to this issue and puts a different balance on it. And basically the court just disregards this recital of the regulation. Now, another point is that under Article 52.1 of the Charter, you can have a EU provision limit fundamental rights, but it needs to set out, according to the case law of the court, it needs to set out explicitly what is the justification to limit this right. In other words, proportionality, necessity, genuinely meet objectives of general interests, etc. It has to set it out explicitly. And Article 26 doesn't set out any of these issues. So it doesn't seem to be dealing at all with limiting religious freedom or ritual slaughter. It's dealing with different issues, because if it was trying to limit religious freedom, it should have set out all of these justifications. This decision, we find, also contradicts a previous ruling by the court in another decision, where it says that this derogation gives expression to a positive commitment of the EU legislator to allow the ritual slaughter of animals without pre-slaughter stunning, in order to ensure effective observance of the freedom of religion. Now, if you make the derogation meaningless, then what happened to this positive commitment? The positive commitment is gone. There is no positive commitment, and basically every country can follow suit and adopt such a ban. Now, one of the justification the court is giving, say, we don't limit so much the freedom of religion because kosher meat can always be imported from other member states. But we think that the court has forgotten that it's the Supreme Court of the European Union. And once we have this ruling, which we didn't have before, that it is legal under EU law to limit and to ban kosher slaughtering, you very fast have other member states following suit and also ban. And then where are the Jews going to get their kosher meat from? So it's a very problematic holding. And if it's allowed, if you have freedom of religion throughout the European Union under the Charter, then it should apply to all member states, not just to some. And finally, let me complete and conclude with the issue of discrimination. Now, what you should know is that the regulation provides that hunting or fishing or killing of animals during sporting or cultural events, they are exempt from the stunning requirement. So in other words, to be able to hunt animals, the European nobility really like the hunting and to see how they kill animals. That is such an important value that this overrides this animal welfare and having to stun animals, and also cultural events. And when this claim was brought before the court, they said, well, this is not relevant because these cultural and sporting events are not done it's not killing for food, so it's not relevant. Well, I would say just the opposite. At least if you kill for food, you have a value that you're certain. But here, what is the value? The value is sport to sport. If you have bullfights, for instance, and bullfights are allowed in many European Union countries. So you have all these people who are enjoying seeing this poor bull being killed and suffering. And that is an important value that we have to protect. But the religious rights of the minorities in the European Union, that is not important enough to be protected. So it seems to us that the judges have an easier time to be tolerant of majority culture and habits, even when they conflict with animal welfare, than they are of cultures and religions of its minorities. So what is next? Well, we still have the Belgian Constitutional Court that has to give a final ruling. This case may go to the European Court of Human Rights, and it will be interesting to see if it goes and what happens there. If we'll have a situation where the Court of Human Rights will override the ECJ. Will we have more member states adopting similar bans? And maybe the next phase is a ban on male circumcision for also all kinds of reasons. So only the future will tell. Thank you very much.
Thank you very much for this. I think this really already opens a large number of interesting and, of course, controversial issues. And now we're going to continue directly to our next speaker, Professor Zivotofsky, and then Professor Harpaz. After that, it makes more sense.
Yeah, let's Guy.
Okay, Guy, would you like to? Yeah, because you speak actually on the same paper. Okay, please. So, Professor Harpaz, you are next.
Thank you, Ayelet. So I would try and use the next 10 or 15 minutes to present the second paper written by Arie, Reich, and myself, which was accepted for publication. And it actually draws on the first article presented by Arie Reich. I wanted to start with a personal note. Both of us deal with the same judgment. The judgment endorsed an outright ban in the name of animal welfare. And if we criticize the judgment, one may come to the conclusion that we are not sensitive enough to animal welfare. Speaking for myself, this is certainly not the case. Some would argue that I feel more comfortable with animals as opposed to human beings. So that's not the case at all. And in the previous millennium, I was acting as a pro bono legal advisor to the Israeli Tel Aviv Society for the Prevention of Cruelty Against Animals. So I'm not against animal protection as such. Arie argued that the protection was legally wrong because it failed to strike the right legal balance. And my argument, which is common to Arie, is that there's a preferable solution, and the solution should be a legal model based on labeling as opposed to an outright ban. So we're speaking about kosher and halal products marketed in Europe, but with a specific labeling indicating the fact that they were produced in a religious rites of slaughtering. And we argue that this model is preferable for 5 different reasons: human rights, the functioning of the internal market, the principle of proportionality, the principle of subsidiarity, and the legal issue of consistency and coherence. So let's start briefly with human rights. When one speaks about protection of human rights, one is in the business of a balancing act. So usually when you are confronted with a conflict between 2 legal rights or norms, you do not ascribe 100% to one norm at the expense of the other, but you try to reach a compromise. So it's a juggling exercise of lawyers and judges. And in this case, we are faced with a conflict between right of religion and animal welfare. And as Arie mentioned, the regulation tries to strike this very, very delicate balance between the 2 conflicting rights. And the same is true with respect to Article 13 of the Treaty on the Functioning of the EU, which focuses on animal welfare, but at the same time insists on respect, and I'm quoting, of religious rights and cultural traditions. Now, the court endorsed the outright ban, and it therefore ascribed 100% to animal welfare and 0% to the right of religion. And we argue that this fails to meet the requirement of EU law to strike this balance. We argue that the labeling model is preferable to an outright or absolute ban, in the sense that it protects animal or prevents or mitigates animal suffering, but without negating the rights of Jews and Muslims to manifest their religious faith. And our proposal is supported, or heavily supported, by scholarship. We found many scholars who actually believe in labeling as such. One of them argued that a legal model based on labeling would succeed, in the sense that it subtly shifts the focus from this very, very, very sensitive and political argument between human rights and animal rights, and animal welfare and right of religion, a very, very sensitive debate, and it shifts the. Okay, that's enough. Enough. It shifts the way and focuses on a much more technical debate pertaining to consumer preferences and choices. We further argue, and that's the second line of argument, that a model based on labeling is preferable in terms of the functioning of the internal market. The model would allow a much greater volume of trade in kosher and halal meat, while promoting the value of animal welfare. And in that respect, one should remember that the EU acts as a normative power, and in pursuit of its trade policies, it acts as a market power in Europe, linking the promotion of economic opportunities and growth with other non-economic values, such as environmental protection or animal welfare. And as Reich argues, the promoting of good governments to the use of trade policies reflects the EU's worldview, and it is its internal constitutional DNA, allowing the EU to act as a moral vanguard. The EU is indeed bound to promote both fair trade and free trade, and it attempts to strike this delicate balance between what the scholarship calls the homo juridicus, the right-bearing citizen, and the homo economicus, the interest-maximizing stakeholder. Now, the regulation itself tries to strike this very delicate balance between social protection and market protection. And the same is true with respect to the provisions pertaining to the free movement of goods. So if you examine, for example, Article 34, 5, and 6 of the treaty. Article 34 and 5 prohibit the adoption of quantitative restrictions in order to protect the market, but Article 36 provides an exception in order to allow member states to protect national non-economic interests, i.e. social protection. Now, as Arie hinted, if the EU would allow each and every member state to adopt either bans or export bans, that would contribute to the dysfunctioning of the internal market. And we believe that a model based on labeling would allow this very delicate balance between the protection of the market and protection of social value, the principle in the Charter itself. Now, the court itself acknowledged that the legality of the Flemish ban should be examined in light of the principle of proportionality, and I'm quoting that the limitations from the judgment itself, that the limitations on the freedom to manifest religion by the Flemish decree, must not exceed the limits of what is appropriate and necessary in order to attain the legitimate objectives pursued by the legislation, namely animal welfare. And the court adds, when there's a choice between several appropriate measures, recourse must be had to the least onerous, and the disadvantages caused must not be disproportionate to the aim to an absolute ban, manifest a less restrictive measure, and therefore the promotion of animal welfare under this regime meets in a much better manner the test of proportionality. And now we rely in the context of proportionality on this very famous seminal judgment of the same course in Cassis de Dijon in the 70s. And if you remember, in that case, the German authorities tried to validate or legitimize a de facto ban on the marketing of alcoholic beverages when they included a lower content of alcohol, arguing that this is needed in order to protect or to advance consumer protection and prevent consumers from being exposed to unfair practices. So that was the German argument, and the court utterly refused this de facto to accept the legality of this outright ban, and instead it promoted the idea of labeling, and I'm quoting from Cassis de Dijon. This line of argument, the German line of argument, cannot be taken so far as to regard the mandatory fixing of minimum alcohol contents as being an essential guarantee of the fairness of commercial transactions, since it is a simple matter to ensure that the suitable information is conveyed to the purchaser by requiring display of an indication of origin and of an alcoholic content on the packaging of products. The fourth line of argument relates to subsidiarity. The Luxembourg court relied on the jurisprudence of the Strasbourg court, the Human Rights Court, which stated that the views relating to kosher and halal slaughtering may widely vary between member states and regions and communities, and this is certainly the case. But the court, in the name of human rights protection, allow each and every member state to adopt its own legal regime in the name of a margin of appreciation, and etc. But we argue that those different national regimes may not necessarily be sensitive or cater for the preferences of each and every consumer in each and every country, community, or region. And we argue that actually, when you speak about subsidiarity, a model based on labeling is much more suitable because it caters for the three different groups of consumers. If you hate or you do not accept kosher products, then you would use the labeling in order not to buy those products. If you insist on kosher, then the labeling would assist you. And if you are indifferent, then you would be indifferent to the labeling. So we argue that this shift from an outright ban to a labeling regime is in fact a shift from member states regulation to citizens, consumers regulation. And that's the title of our paper, Voting with Your Trolley. And we argue that when you move from states to citizens, this is in fact in line with the letter and spirit of the principle of subsidiarity. The fifth and last line of argument pertains to legal coherence. Now, the EU is bound by the rule of law. And when you speak about the rule of law, you speak about legal norms freest as far as possible from legal contradictions. And when you speak about the court, you would expect a court, certainly a Supreme Court, certainly the Supreme Court of the EU, to act in a very consistent and coherent manner. Now, I refer in that respect to the Psagot case of 2019, and I must say that I support this case. I mean, I do not have anything bad to say about this judgment as such. But if you read the judgment, you would realize that the court said three things. It said that the establishment of settlements is done in contradiction of some of the most paramount rules of international law. I personally agree. The court said that those breaches of international law, they are closely linked to consumer ethical considerations that might influence purchasing decisions, and hence the marketing of settlement products within the EU should be subjected to strict labeling requirements. I have no reservations as such, but my reservation is that if the court is willing to accept or address those very grave breaches of international law through labeling as opposed to an outright ban, then a fortiori, I mean, der kal vachomer, it should accept the infringements of animal rights through labeling as opposed to an outright ban. Now, I believe that I do not have the time, but our paper actually admits that our model includes 3 or 4 major drawbacks, and we try to address those drawbacks. I hope that we do it in a satisfactory manner. So the bottom line is that we believe that in the EU and elsewhere, society should protect animal welfare. And we believe that the court was right in trying to protect the value of animal welfare. This is certainly true with respect to an institution that is committed to a normative vision, and maybe lead the word normatively. So we perfectly agree with this vision. But we argue, or I argue, that this protection was pursued in an unbalanced and hence illegal manner. And I argued that there's an alternative which is better in terms of human rights, functioning of the internal market, principle of proportionality and subsidiarity, and legal coherence. So thank you very much for your attention.
Thank you for this. Indeed, we are going to proceed directly to the third presentation before opening it up for discussion. Thank you, Professor Zivotofsky, for joining us. The floor is yours.
Okay, thank you. I hope you could see the screen, the PowerPoint. Okay. I would like to talk about, first of all, I want to say that the previous 2 speakers, you've convinced me, Arie, that the court was in grave error, but I'm going to talk about this from a legal perspective. I want to talk about the scientific and Jewish legal aspects of modern methods of pre-slaughter stunning. Arie said we're waiting for the Belgium court. We're not waiting for the Belgium court. The news this past week was last Thursday. The Belgium court indeed ruled and upheld the ban on religious slaughter. I had submitted a brief about the scientific aspect, and they did not even quote it. I don't know if they gave any attention whatsoever to the science. How does this relate to Jewish integration in Europe, this ban that now is in place? Well, the Conference of European Rabbis president said that removing the Jewish community's ability to be self-sufficient sends a clear message about how Jews are regarded within Belgium and how authorities see their future. And the World Jewish Congress president, Ronald Lauder, said, by prohibiting religious slaughter without stunning, the Court of Justice of the EU has placed a potentially terminal obstacle to continue Jewish communal life in Europe, meaning these 2 leaders of within the European community see these bans as very significant to continue Jewish integration in Europe. The current situation in the EU, as of October 2020, in a fact sheet put out by the United States, informs us that the numbers are going up of those countries that are banning or limiting shechita. All ritual slaughter is banned, by the way, a word that those of us in the field don't like, the ritual slaughter. It's banned in Slovenia. Pre-cut stunning is required already in 15% of the countries, Belgium in 2 of the 3 states, Denmark, Iceland, Liechtenstein, Norway, Sweden, and Switzerland. Many of these countries do not have significant Jewish communities, and so it's not a big burden. Some of them do. Belgium now among this group, I think, has the largest of the communities. Switzerland's ban goes back furthest, over 100 years. There are two quotes from the decision that I want to discuss regarding their science and how it holds up. Note that the decision is in French, Dutch, and German. The link to the French version is over here. So what I'm quoting now is in translation. They said, and Arie, I think, mentioned both of these, the ban on slaughter without stunning, however, responds to a pressing social need and is proportionate to the legitimate objective pursuit of promoting animal welfare. So again, the Belgian court said this, upholding what the European Constitutional Court had said. I would like to discuss whether this is true, that it promotes animal welfare. And they said, furthermore, the possibility of reversible stunning during ritual slaughter cannot be interpreted as prescribing how a religious rite is to be performed. I want to discuss that aspect as well. So what is shrita? Well, shrita is the Jewish method of animal slaughter. It involves severing the primary vessels of the neck. It must be done in a continuous cutting motion. And this is very crucial. It must be done using an exquisitely sharp and absolutely smooth knife. These two requirements and some of the others are not part of halal, and that's why I'm going to stick to shrita and talk only about shrita. The lawsuits all lump together shrita and halal. I'm talking only about shrita. Kosher slaughter also involves a post-mortem to ascertain that the animal was healthy at the time of slaughter. And the practitioner is in general what we call the shochet, is a highly trained, respected, and decently compensated member of the Jewish community. Here is an example of what shrita knives look like. Again, it has to be sharper than any kitchen knife that you have and absolutely smooth with no nicks. This is how the shochet checks the knife. Must be checked before and after the slaughter of every animal. This is very important in terms of the pain and the suffering of the animal. The cut itself is from a smooth, sharp knife, which causes minimal pain. Those who have been cut with a razor or even a paper cut know that the cut itself has minimal pain. Afterwards, there may be lots of pain, but the cut itself is minimal pain if it's smooth and a sharp knife. And in the way shrita is done and the way the animal is held, after the cut is made, the neck pulls apart so that the wound ends do not touch. And if there's no touching of the wound ends, that means there's no stimulation of the pain receptors, and thus that minimizes the pain in the post-cut. When a person gets a paper cut, for example, the wound ends are touching, and the pain receptors are being stimulated. After shrita, that's not the case. During the period of blood loss, two things. First of all, exsanguination, meaning death by bleed out, is considered a pain-free way to die. There's no actual pain. A human being who will die from blood loss, meaning an accident victim who's lying in the street waiting for the ambulance, is not in pain, but they are suffering because they understand an awareness of an impending death. An animal likely has no consciousness of the impending death. Thus, there's no pain in terms of pain receptors, and there's no suffering because they're not aware of what's taking place. Time to loss of consciousness. The loss of consciousness occurs due to an exceedingly rapid drop in the blood pressure and loss of blood to the brain. In sheep, this loss of consciousness is in less than 10 seconds. This is agreed by all, and that's why, for example, places like Australia, which require post-cut stunning, do not require it in sheep. In cattle, it's slightly longer. One may see convulsions that continue long after, but they're not an indication of pain or suffering. The animal has lost consciousness long before. Skip that. Religious codes, the Jewish religious codes were aware that sometimes the animal may be slow to die, and they recognized the need to minimize suffering. So, for example, the authoritative code of Jewish law, the Shulchan Aruch, rules that if, after a proper slaughter, a particular animal bird is slow to die, it must not be allowed to suffer. Rather, a fatal blow to the head should then be delivered. Meaning, the Jewish law is very much aware of the need to minimize suffering. Jewish law talks about the fact that shrita is considered a minimally painful way of slaughtering. And if, in any event, some sort of event occurs that would lead to pain or suffering, it must be mitigated. If one is interested in more detail about the physiological insights into shrita and the pain involved, within the veterinary record of the British Veterinary Association, an association that continuously comes out against shrita, and a human cardiologist S.D. Rosen wrote an article in 2004 where he details all of the physiological aspects of shechita. Stunning. Arie mentioned the difference between reversible, non-reversible stunning, and mentioned only one of the methods of stunning. There are really four basic methods used today in Europe. One is a penetrating captive bolt, essentially a bullet to the head, which penetrates the skull. It's absolutely non-reversible. It essentially kills the animal. A non-penetrating captive bolt, which is what Arie had mentioned, used often in cattle, is often also non-reversible. It's like taking a sledgehammer to the brain and smacking the animal on the head. Electrical stunning is the most common method used for poultry and also a common method used for sheep and cattle. It involves electrocuting the animal. And gas stunning is used in some places as well, more for rabbit, which doesn't affect us in the kosher industry, but also gas is sometimes used for different types of fowl. It basically involves suffocating the animal, and I have no understanding of why this is considered a legitimate method. Watching the animals, you can see it's terribly barbaric. Stunning has been used in Europe for centuries. You could see how they stunned pigs in medieval Europe. 18th century, how they stunned cows, again with just a hammer to the brain. And this is Berlin, 1903, a stunning method. Looking at these methods, what was considered state of the art for the time, today we can only cringe. And it makes one wonder what future generations will have to say about our sophisticated state-of-the-art methods, the various methods of gas or electrical, etc. The earliest record of concussive stunning, meaning a non-penetrating bolt, is actually mentioned 1500 or 1800 years ago. The 2nd century Mishnah, explained by the 5th century Talmud, records that an attempt was made to introduce non-penetrating concussive stunning to the Jerusalem temple when they slaughtered cattle, and it was swiftly banned by the high priest as it renders the animal not kosher. Meaning, as Arie mentioned, Jewish religious law doesn't change readily, and indeed, this law that's smacking the animal on the head with a non-penetrating captive bolt, that's not acceptable for kosher slaughter, goes back over 1,500 years. This is not a new innovation of the rabbis today who want to just cause trouble for the EU authorities. This is what the modern captive bolt looks like when used for cattle. And I think a very important thing about electrical stunning, which is really what they want to force upon the kosher slaughter in Europe when it comes to both cattle and to animals, to fowl and to cattle, is often we use, especially in neuroscience biology, we use animal experimentation to shed light on how something would affect humans. In this case, we actually have a human experiment which can shed light on how animals are sensing something. Electrical stunning, as done in cattle, is more akin to human electroconvulsive therapy, used still today very much to treat depression that doesn't respond to other treatments, rather than to epilepsy grand mal seizure, which is what the authorities claim the electrical stunning is doing. And all of the negative aspects of unmodified ECT. What's unmodified ECT? It means electroconvulsive therapy without anesthesia. And unmodified ECT is unethical and widely banned today by all medical associations. It causes pain, it causes convulsions. It's simply considered torture. And therefore, ECT, when used in the medical world today, is always done in the modified form, meaning with anesthesia before the ECT is given. What is being done to these animals is essentially unmodified ECT. Often it will result in something that resembles an epilepsy grand mal seizure, which is not unpleasant. However, very often there will be a subconvulsive shock, which is very painful and occurs even in hospital settings. Meaning that an animal that is misstunned, or even one that is stunned with appropriately positioned electrodes and optimal current, but experiences subconvulsive stimulation, yields results that are clearly less humane than slaughter without stunning. Such events are unavoidable in the hospital. In the hospital, we have doctors who are treating the patient. You have a patient who's being cooperative. You have a much more unlimited time, and yet you often get subconvulsive stimulation, which would be considered torture without the anesthesia. And yet, this is what they want to impose in a slaughterhouse, which is dirty, fast-paced, untrained workers, it clearly is going to result in many misstuns or subconvulsive stimulations. And is it even useful? Lishitosum, according to their argument, in bovine, the shorter epileptic effect is 20 to 90 seconds. They argue, and it's not true, they argue that often bovine time to unconsciousness could be up to a minute. So electrical stunning doesn't even work, according to their positions. Can it be done right? In fowl, absolutely not. Electrical stunning is not done by putting electrodes to the brain in chicken. You hang upside down the chicken. Again, a big problem from an animal welfare perspective. They move along on a conveyor belt. They get dunked into an electric bath. Often they're flapping their wings and they don't go into the water enough. It's simply impossible to do electrical stunning on chicken in a humane method. And that is the majority. The majority of animals slaughtered by far in terms of numbers is chicken. In bovine, again, it's very difficult. It's dirty, fast-paced environment, less than ideal workers, leads to misstuns and subconvulsive. If anybody wants more details on this, here's a paper with a psychiatrist. Psychiatrists are the ones who do ECT. It appeared in the leading journal relating to animal slaughter.
I'm afraid we're running out of time. Sorry to interrupt, but would it be possible?
So I'll finish very quickly. Why do they want to impose this? When you use penetrating stunner, you could kill 385 cattle per hour. In kosher, it's between 85 and 100, depending on the restraint system. A guy mentioned stunning, labeling. If you're going to label guy, I think it has to be all meat has to be labeled, not just the kosher, and it has to be honest. This animal was killed by smashing the animal over the head to crack its skull. This by smashing through and crushing the skull. This by electrocuting gas chamber, or state by kosher, slitting the throat of an animal. Let me get therefore to the end. The decision of the court said it's legitimate objective of promoting animal welfare. I think the science does not say that, but the upheld legislation does not promote animal welfare. They said it's not prescribing how religious right is to be performed. Indeed, it's banning the religious right. So what I wanted, the take-home message, as kosher noted, kosher laws require the slaughtered animal be healthy. Animals that have been blasted through their head with a bolt, electrocuted, suffocated, cannot be defined as a good health. So my claim is not that from an animal rights perspective, shechita is the only acceptable method, but rather, based on the science and religious requirements, it is an acceptable method and should be viewed as such by the secular law. Any attacks on shechita today are not taking into account the science, and again, the court did not. Whether they're motivated by anti-Semitism, xenophobia, or ignorance, I don't know. I can't judge what's in their heart, but they're clearly not taking into account the science. And the future, well, in this era of COVID pandemic, we are constantly urged to heed science. In this decision, the court has not done that. They gave into populism, and that's a shame.
All right, thank you very much. So I think after these three presentations, the probably several questions from the audience, because you raise here both scientific and legal aspects of the problems of this ban, but also the more general question, because of course this legal move is not the only one, right? You mentioned other possible bans on male circumcision and issues that have been in different European legal systems already, have been around. So we only have 15 minutes for the audience to ask their questions and for you speakers to reply. And my suggestion is that we'll just take a round of questions, and you can then pick and choose according to the time available which points you'd like to respond to. So if people that are participating via Zoom would like to ask a question, simply please just write them through the chat, and then we can all see them. And Maya, you suggested taking a round of questions from the seminar room. So until you collect questions there, and until we see or hear questions on the chat, I would ask one general question. Indeed, how far would you take the argument that religious practices do not have to adjust themselves to constitutional principles in places of conflict? It just seems that on this particular case, it's very easy to show that the conflict is not there, or it's as you said from the legal perspective, that the balance is not done fairly, and from the scientific perspective that we don't really do much here, if at all, to advance animal welfare. But it seems that in other issues this might be more tricky. For example, the German legal debate about male circumcision, and I wonder how far would you take the principle that freedom of religion is first? And that would be one general question. Iris, would you like to ask?
Yeah, thank you very much. So my question would be regarding the criticism about of the court. So it seemed to me that many arguments were already raised before the court and therefore discussed. The question whether do you hear me? Can you hear me?
Yes.
Okay, that's good. So the question whether whether there is an alternative to pre-stunning, or pre-stunning is the optimal way to protect the animal welfare. The court answered about the long procedure in Belgium, discussing all that, and allegedly the argument that the shechita is also somehow protects the animal welfare was rejected. The labeling was also rejected. So it seems to me that what we are talking about is more whether there is a least restrictive measure, whether shechita is a least restrictive measure or not. But I think, that's a question of, first of all, it's a question of balancing. So you don't agree with the balancing of the court, but that's, your opinion against the court's opinion. But it's because many arguments that the court is doing, for example, the question whether pre-stunning is really affecting the essence of the right. So you might say, but it affects the idea of kosher eating, but it doesn't affect the essence of a right in the sense of the European Court of Justice, which tells you that affecting the essence, meaning that you will not be able to practice your right. So we all agree that the Jews can still practice their religion in Europe, although they might not be able to eat fresh meat kosherly slaughtered. So what is exactly, except the least restrictive measure, and even in the least restrictive measure, I think the argument should be more broader in the sense that the court argues for the optimal protection on animal welfare, and you might, with the labeling or alternative to knives, a better shechita, which was suggested by the Advocate General, you argue that there is a least restrictive measure which is not optimally reaches the goal of animal welfare. So will that be the argument? Because otherwise it seems to me it's a different balancing, which can be more convincing or less convincing, but less, it's not a very, I think, persuasive criticism on the court. The final question is, there is this argument that the court a Christian court cannot deal with Jewish shechita. I wonder whether you made any comparative analysis how a Christian court deals with Christian arguments, like a Christian guy who got married is going to be fired by a Catholic church or employment. So whether it is a secular court which applies secular rules, or it is something that we can say it's a Christian court against Jews and Muslims only.
Before you reply, Maya, are there questions from the audience?
Thank you, Ayelet. There are no questions, if I said correctly, from the room, but it is my understanding that there is no possibility to appeal over an European Court of Justice. Is that this is the highest level within the EU system of law? So what can actually, the only thing that can change is to go back to the Flemish legal system and try to change it from within.
What about the European Courts of Human Rights? Is it not still an open for?
So whether it could be
the European Court of Human Rights says that import is enough. If you give importation, it's enough. Possible to import kosher food, and that doesn't have to be only from the European Union. It can be also for third states. It's the question whether there will be such a states, but otherwise it says that importation isn't so allowed that.
Great. So we have a couple of minutes for each of our speakers to answer to the points that you'd like to.
So with respect to the alternatives, obviously there's the option of going to Strasbourg. Strasbourg is not bound by Luxembourg and not by vice versa, but I'm not a prophet, but it's very unlikely that they would adopt conflicting verdicts as such, but who knows. With respect to the question whether EU judges or secular judges or Christian judges may accept arguments pertaining to Jewish faith, etc., I believe that when you appoint a judge, he's competent and authorized and bound to accept any legal argument, and he's supposed to be able to deal with each and every argument, including arguments stemming from Jewish law as such. Obviously, under human rights regimes, when you speak about minority rights, certainly small minority rights, certainly when you add the sensitivities of Jewish history in Europe, then the court must be extremely sensitive to minority rights. But I see no problem whatsoever in the fact that a Christian court, which is not defined as such as a Christian court because the EU doesn't define itself as a Christian club, I see no problem whatsoever in principle, in theory, of a civil. I don't like the word secular. I think it's a civil court dealing with religious arguments, just as I wouldn't mind the Supreme Court of Israel overruling a rabbinical court. I see no problem in that respect.
Yes.
Shall I proceed?
Yeah, would you like to proceed?
Yeah. So first of all, I'd like to address the first issue that Iris raised about that there was a certain process, etc. I also was under that impression, Iris, when I read the decision that there had been like an extensive process within Flanders with consultations with the communities, with consultation with the scientific community. And we spoke to the head of the Jewish community in Belgium, Yoav Ben-Izri, himself is a lawyer. He said there was nothing of the kind. There was no consultation, not of the scientific community, nor of the Jewish or the Muslim community. They appointed some guy with a very weak scientific background, and he produced some paper and with close to little scientific basis or quotations or references, deciding that this is the solution and this is the scientific best way of slaughtering animals. So that answers that question. Regarding, I agree with you, Iris, that there is a big difference between male circumcision and slaughtering. So if we'll have a ban on male circumcision, that is a much stronger manifest limitation on religious freedom than slaughter. However, the court did agree that slaughter is also a manifest expression of religious freedom. I should mention, for instance, in halal slaughtering, and also in the kosher law, there is it's considered like a mitzvah. It's considered a commandment. You are performing in a certain way, and there are blessings said. In halal slaughtering, there is a verse from the Quran mentioned. So it's a kind of a religious ceremony in that sense. So there is a certain amount here of manifest religious action. But besides that, there is a very strong issue here of respecting the rights of religious minorities. And when you allow the general majority to eat meat, you don't force the majority to become vegetarian. You do allow them to eat meat of their choice. Then you should also allow minorities, certain religious minorities, to perform the same thing, and not to force them to look for their meat somewhere else if they can or if they cannot receive it at a very high price. By the way, we mentioned Switzerland. I'm in Switzerland right now. Kosher meat in Switzerland is about twice as expensive than it is in other countries, including the United States. So I think there's a problem there. Regarding what the future holds, so the Belgian court just issued the decision. I wasn't aware of that. I think I agree with Guy that the chance for the European Court of Human Rights to rule otherwise is not very high. I think that there may be, if there is a chance, I think it could happen maybe on the European Union level, that EU Council would clarify the regulation in the sense that Article 26 does not override the derogation found in Article 4.4, and then the ruling would become irrelevant, I think. And then but will they do that from a political point of view? I'm not sure.
We have now, before you say your points, Alfred, did you want to ask a question too? We are just remind everyone that we are now, it's 12:15, so technically our time is up, but we will take 5 more minutes because we started late.
I'm going to ask a question to the very interesting expose of Arie, and also of Arie and Guy. I think, Arie, that it's very dangerous to use the argument, in my opinion, to use the argument that if the European Court of Justice prevails, Jewish life in Europe will be impossible, or will be curtailed, or whatever, because goys, to call them, will tell you, so what about Israel? I mean, can a Christian conduct a normal life as a minority in Israel? You will have then to decide, to stress, well, it's a Jewish state, and you know, the whole thing, and this state is for Jews, and goys should not be living among us. You will have a mess here. You will have a mess. How are you going? I mean, if you stress that this European Court of Justice makes life of Jews in Europe impossible, a non-Jewish person in Israel will tell you, and what about Israel? You must apply symmetry. Or will you say, no, it's not symmetrical? I want you to respond to me.
Thank you for the question. So, okay, so far, last sort of points.
Okay, so yes. First, I want to say, in terms of Alfred's question, I'm not sure I see the symmetry. In Israel, we don't have laws that ban other religions from practicing their religion. We do ban proselytizing, for example, but we don't ban church services. We don't ban Muslims from doing their religious activities. I'm not sure I see the question. But I'll let Arie answer that in a minute. I just want to respond to Iris and to others, because you're asking where the future is. The future, I'm very worried about, because the importation, right now, every single country that bans shrita permits importation of kosher meat. But it really is a little bit hypocritical, because if you believe that shrita is non-humane, then you shouldn't be just sending that non-humane activity offshore. And Israel, for example, tried doing that. When Israel banned about 10 years ago foie gras, the force-feeding geese, they banned production here in Israel, and there was then an attempt to ban the importation as well. And I argued strongly against that, because if we would have banned the importation of foie gras, that would send a message to Europe that we think foie gras is inhumane. We ban its production, and obviously its importation if it's inhumane. So too, Switzerland will say, I think shrita is inhumane. We're going to ban the activity as well as the importation, because the current situation really is hypocritical. And thankfully, Israel did not ban the importation of foie gras, because I think the message to Europe would have been very detrimental. But on the other hand, I think it's going to be coming, because it doesn't make sense that Switzerland should say, we have the ability, let's say, to regulate how the shrita is done. We're going to forego that right And instead, we're going to let them do the shechita in Hungary, where the regulation is less restrictive, and it's going to be more problematic from an animal welfare perspective. Meaning, if they would permit it in Switzerland, it would be better for animal welfare than having it done in Hungary and imported. So I think the future does not bode well for the importation of meat to these countries. And I think that it's problematic. And the argument there is going to be, I think, more difficult. The legal arguments that Arie presented to permit shechita, I think, are much stronger than the arguments that are going to exist to maintain the legality of importation. Okay.
Thank you. Arie, would you like to make a final comment for this session? We don't hear you.
Yeah, sorry. I agree with Arie. I didn't understand Alfred's point, because as far as I know, we do not restrict the Christians or Muslims to perform the religion in any manner or form. So I didn't understand the question.
All right. So I think thank you again, everyone, for participating, for contributing to the discussion. There is still a lot to say, and hopefully we'll find another forum in the future to continue this conversation. Maya, I hand it back to you. Thank you.
Thank you, Ayelet, and thank you for all the participants in the panel. It was, as a vegetarian, I have to say, I'm glad that we have another hour and a half before lunch. It was tough to hear, but it was extremely interesting, and I think the values, the conflicting values, are definitely something that is, there's a lot to say about that. So thank you so much, and we'll reconvene in 15 minutes, so at 12:35 for the next panel. Thank you.
תודה רבה.